Hello. Today we're talking about some nuances regarding the duties and powers and obligations of a liquidator, the conversation we started some time ago. Uh, okay, everything is going marvelous, and the estate is solvent, and there is a lot of money in the estate, but it still will take quite some time. Some time is like around several months, normally about a year, sometimes more than a year, depending on the situation and on the complexities with the assets. But the heirs might become uh, impatient, let's put it this way, and maybe sometimes irritated because of all that, and they might start blaming you for all the delays. So the code, the Civil Code of Quebec, allows you to proceed with distributing of some of the assets to the heirs, as long as you make it sure that it's enough left to pay all the debts and, of course, uh, heirs by particular title. It's not an obligation. It's to your discretion. You might go with that, you might not go with that. But if you do, again, remember to proceed with all the caution and all the paperwork so that if there are some other heirs, because again, you're not obliged to distribute equally. You can distribute some to some of the heirs and not to the others. So there might be a conflict and you will need to protect your responsibility. Uh, if, as we mentioned before, you can see that the estate doesn't have enough assets, then you should not deliver the property to the heirs by particular title before you understand that all the creditors, including the government, are paid for whatever the debts. If not, you might become personally responsible. You don't want that. And do remember that even if the heirs try to put pressure on you and request something from you, pretending that it's actually their property, no, it's not yet. And it's your obligation to see it through that the creditors are paid. So if you go after their requests, however insistent they might be, if something goes wrong, it might become your problem, not theirs. So sometimes you have to be firm about all that. Then, what if the heirs don't want you to sell a house, for example, but you need to because the estate doesn't have enough assets to pay the creditors? Uh, Here it depends. On one hand, yes, you have to sell because you have to pay the creditors. On the other hand, if in the will, preferably a notarial will, it is said that your powers are full administration of property, then you can sell without asking heirs normally. If there is no such a stipulation, or if it said simple administration of property, then normally when you proceed with a sale of some significantly valuable property, you will need to obtain authorization from the heirs, and maybe you can negotiate that they buy out if they really want that property to stay in the family or wherever. Maybe they would want to buy it out from the estate so that the estate would have money to pay. But again, remember that you're responsible for the estate while you are the liquidator. So if they offer you significantly less money, offer the estate, not you personally, than you might otherwise obtain from the market, then it might not be a good idea to proceed because, again, your responsibility might be involved. Or at least if you proceed this way, be sure that all the heirs agree and preferably sign something to that matter and to the effect that your responsibility is not in danger. In any case, it would be a good idea to read the will first and see if you have full or simple administration, whatever is there. Also, if there is an explicit instruction in the will and if it's not against public order, of course, and if you have doubts, it's again a good idea to go to see a lawyer and maybe to go to court for clarification. But again, let's say the stipulation in the will is not against public order. But the heirs don't want you to go that way. Your obligation is to follow the instructions in the will. And if you're not comfortable with that, again, maybe it was a good idea to step down from the office before, from the beginning, because now, if you're already in the process for several months or maybe a year, there are obligations you have to fulfill, there are reports you have to provide, and those reports should be accepted, or they might be contested again contested in court against you. So it might be not a good idea to think afterwards. It's better to think from the beginning before you decide if you accept or not the office of the liquidator. Anyways, if you did not think in advance, and then at some point you became really uncomfortable with your duties and with the heirs or the rest of the heirs that's possible, and you think that it's a good time to stop and step down from the office, remember not to do it just like that. Because when you step down from the office and one of those who are in conflict with you become a new liquidator, that person might try to put all the responsibility for all the mistakes, even benign mistakes, on you in the hindsight. So before doing that, you have to protect your responsibility. But about that we'll talk later in maybe other video. Just remember that the office of a liquidator means responsibility. Think of it. Thank you and have a nice day.